Hello everyone, as you all are aware that we are daily posting videos on important case related MCQs. In furtherance of that, in this video, we will discuss case related MCQs of contract. So the first question is, which judicial pronouncement of the Queen's Bench of England had dealt with the concept of general offer? The correct answer is A. Carlisle versus Carbolic Smokeball Company. Question number 2. Union of India versus Madala Tathaiya is an illustration where the tender was in the form of standing offer. Which one is the famous case related to the general offer? Correct answer is Carlisle versus Carbolic Smokeball Company. Is a case related to general offer. Which one of the following is a leading case on the point of communication of offer? Correct answer is Lalman Shukla versus Gauri Datta. In Carlisle versus Carbolic Smokeball Company, the court ruled A. That an offer made to public at large is nudum pactum. B. That a general offer is no offer. C. That an offer can be made only to a particular person. D. An offer need not to be made to an ascertained person. The correct answer for this is D. An offer need not to be made to an ascertained person. Which of the following case is related to the cross offer? Correct answer is B. Tin versus Hoffman and Company. Question number 7. In case of general offer, there is no need to communicate the acceptance if not required by the proposer. This has been held in A. Carlisle versus Carbolic Smokeball Company. In which of the following cases, which case relates to general offer? Correct answer is Lalman Shukla versus Gauri Datta, Carlisle versus Carbolic Smokeball Company. They both cases related to the general offers. Generally offered to world at large does not make it necessary on the part of the acceptor to communicate his acceptance. This is well explained in Carlisle versus Carbolic Smokeball Company. An offer need not to be made to all the world, which is to ripen into a contract with anybody who comes forward and performs the condition. It is an offer to become liable to anyone who, before it is retracted, performs the condition, and although the offer is made to the world, the contract is made with that limited portion of the public who come forward and perform the condition on faith of the advertisement. Our statement is attributed to Lord Justice Bowen in Carlisle versus Carbolic Smokeball Company. Match the following. Match list 1 and list 2. List 1 says A. Proposal, B. Invitation to make an offer, C. Communication of acceptance of offer by acceptor himself, D. Revocation of offer. The correct match of list 1 and list 2 is A. Proposal. This is related to Maharashtra Rajya Sarkari Kapas Utpadak Pranan Mahasabha Limited versus Mangbhanga Chaudhary. A. Proposal. Invitation to make an offer. This is related to Granger and Son versus Gog. C. Communication of acceptance of offer by acceptor himself. Correct answer is Powell versus Lee. D. Revocation of offer. Here the correct answer is Hanthorne versus Fraser. Match list 1 and list 2. Again, list 1 says A. Lapse of offer, B. General offer, C. Communication of proposal, and D. Implied proposal. Here the correct match will be A. Lapse of offer. Correct answer is Hawthorne versus Fraser. General offer B. Correct answer for B is Week versus Tablet. Communication of proposal. The correct answer is Coffee Board versus CCT. Implied proposal. The correct answer is Lalman Shukla versus Gauri Datta. The leading case of Carlisle versus Carbolic Smokeball Company is related to general offer. A's nephew has absconded from his home. He sent his servant to trace his missing nephew. When the servant had left, A then announced that anybody who discovered the missing boy would be rewarded. When the servant came to know about the reward, he brought an action against A to recover the same. But his action failed. It was held that the servant was not entitled to the reward because he did not know about the offer when he discovered the missing boy. Name the case on reading the facts. Correct answer is Lalman Shukla versus Gauri Datta. These were the facts of this case, Lalman Shukla versus Gauri Datta. List 1 and list 2. Case and principle. List 1 case Lalman Shukla versus Gauri Datta, B. Macpherson versus Apanna, C. Banwari Lal versus Sudarshan Das, D. M.C. Chaku versus State of Travancore. Correct answer will be Lalman Shukla versus Gauri Datta, general offer. Macpherson versus Apanna, the correct answer is invitation to treat. Manwari Lal versus Sudarshan Dayal. Correct answer is intention to create legal relationship. And MC Chako versus State of Travancore. Correct answer is privity of contract. Match list 1 and list 2. Carlyle versus list 1 says A. Carlyle versus Carbolic Smokeball Company. B. Fisher versus Bell. C. Tin versus Hoffman and Company. And D. Harvey versus Facey. The correct answer will be Carlyle versus Carbolic Smokeball and Company. It will be offer at large. Fisher versus Bell. The correct answer is invitation to treat. Tin versus Hoffman and Company. Correct answer is cross offer. And Harvey versus Facey, as we have already discussed, this is quotation of price. List 1, match the following: Balfour versus Balfour, Oxford versus Davis, Dunlop versus Higgins, and Hyde versus Rich. The correct answer for this is Balfour versus Balfour. Correct answer is revocation. Balfour versus Balfour. Correct answer is intention to create legal obligation. Balfour versus Balfour, intention to create legal obligation. And Oxford versus Davis. The correct answer is revocation of offer. In Dunlop versus Higgins, correct answer is acceptance through post. And Hyde versus Rich, correct answer is counter offer. In which of the following cases the court rendered decision on public offer? Correct answer is Securities Exchange Board of India versus Akshaya Infrastructure Private Limited. Bank of India versus O.P. Swarnkar AIR 2003 Supreme Court 858 is an important judgment on the following issue. Correct answer is invitation to offer. An offer cannot be accepted unless and until it has been brought to the knowledge of the person to whom it is made. It was held in B. Lalman Shukla versus Gauri Datta. We have already discussed the fact of this case. Which of the following is incorrectly matched? Correct answer is Feldhaus versus Bentley communication of offer. This is incorrectly matched. So these are not correctly matched. But if we see the option 2, Samuel versus Anantnath, privity of consideration, Lowy versus Pierce, agreement in restraint of marriage, Taylor versus Caldwell, destruction in subject matter. B, C and D are correctly matched. But the question here asked is incorrectly. So the correct answer will be A. Acceptance. In which of the following cases it was held that a contract through telephone is concluded at a place where the acceptance is heard? Correct answer is Bhagwan Das, Govardhan Das, Kedia versus Mezersons, Girdhari Lal, Purushottam Das and Company. Consider the following statements. In Bhagwan Das, Govardhan Das, Kedia versus Girdhari Lal, Purushottam Das and Company, it was laid down that first, Section 4 does not imply that the contract is made qua the proposer at one place and qua the acceptor at another place. Second, the communication of acceptance should be from a person who has the authority to accept. Information received from an unauthorized person is ineffective. Which of the following statement is correct? Only one is correct, which says that Section 4 does not imply that a contract is made qua to the proposer at one place and qua the acceptor at another place. For an acceptance, mere mental resolve to accept would not be sufficient. There must be some external manifestation of the intent by speech, writing or other act. Correct answer is Bhagwan Das versus Girdhari Lal and Company. The rule laid down in Adam versus Lentswell was approved by the House of Lords in Dunlop versus Higgins. A contract over a telephone becomes complete at a place where the acceptance is heard. In which case it has been laid down? Bhagwan Das versus Girdhari Lal. Which of the following case it was held that a contract through telephone is concluded at a place where the acceptance is heard? Correct answer is Bhagwan Das versus Girdhari Lal. Consider the following statement. In Bhagwan Das, Girdhari Lal, Kedia versus Girdhari Lal, Purushottam Das and Company, it was laid down that Statement 1. Section 4 of the Indian Contract Act 1872 does not imply that a contract is made qua the proposer at one place and qua the acceptor at another place. Second statement, the communication of acceptance should be from a person who has authority to accept. Information received from an unauthorized person is ineffective. Which of the statements are correct? Only one is correct. We have already discussed this question. When a contract is made on telephone, it becomes complete at a place where the acceptance is heard. In which of the following it was held? Bhagwan Das versus Girdhari Lal. match. Acceptance, list 1, A acceptance, B cross offer, C minus contract, and D res. Here the correct match is A acceptance. This is acceptance must be communicated. A cross offer, no contract concluded. Minus contract is void ab initio. Res extincta, courtier versus hasty. Again, list 1 is case and list 2 is rule laid down. So the list of cases are: A. Ramsgate Victoria Hotel Company versus Montiflora, B. Tin versus Hoffman, C. Household Fire Insurance Company versus Grant, and D. Fitch versus Snedeker. Correct match will be Ramsgate Victoria and Hotel Company and Montiflora. Correct answer is 4. Unreasonable delay in accepting offer causes it to lapse. B. Tin versus Hoffman. Correct answer is cross offer do not create contract. Household Fire Insurance Company versus Grant. Here the correct answer is acceptance complete when the letter of acceptance complete when the letter of acceptance is posted. Fifth versus Snedeker. Here the correct answer is communication of offer cannot be waived. In the case of a contract, the information received from an unauthorized person is ineffective was formed in B. Powell versus Lee. In which of the following cases the Supreme Court held that in order to create a contract, acceptance of an offer and intimation of acceptance by some external manifestation which the law regard sufficient is necessary? Here the correct answer is Bhagwan Das versus Girdhari Lal and Company. Following is a case on promissory estoppel. Correct answer is Kedarnath versus Gauri Muhammad, Delhi Cloth and General Mills Private Limited versus Union of India, both A and B. A valuable consideration in the sense of law may consist either in some right or interest or benefit accruing to one party or some forbearance, determinant, loss, responsibility given, suffered or undertaken by the other is well explained in. Correct answer is Curie versus Miza. Promissory estoppel against the government agencies is decided in. Correct answer is Delhi Cloth and General Mills Limited versus Union of India, AIR 1987. Consideration means a reasonable equivalent or other valuable benefit passed on to the transferor to the transferee. Similarly, when the word consideration was qualified by the word adequate, it makes the consideration stronger so as to make it sufficient and valuable having regard to the facts, circumstances and necessities of the case. Our principle was laid down in A. Sonia Bhatia versus State of UP. Read assertion and reason and answer the using code given below. Assertion: a contract is a property in the nature of a promise supported by some consideration upon which either the remedy of a specific performance or that of damages is available. Reason is our principle is laid down in Sunrise Associate versus Government of NCT Delhi. Correct answer is B. Both A and B are incorrect. The doctrine of promissory estoppel was used by Justice Denning to uphold the promise of a creditor to accept a smaller sum in discharge of a larger sum, if such a promise is acted upon by the promise, notwithstanding the absence of consideration. Identify the relevant case in which the doctrine was so developed by Justice Denning. Correct answer is C. Central Inland Transport Corporation versus Mumbai Port. The principle of privity of contract was held as not applicable in an action for tort in Ashby versus White. Match list 1 and list 2. List 1. In list 1, the options are Durga Prasad versus Baldev, B. Abdul Aziz versus Masoom Ali, C. Dutton versus Pule, D. Tweddle versus Ettingson. And list 2, we have to match the following. Here the correct answer is Durga Prasad versus Baldev. Correct answer is act was not done at the desire of the promisor and hence no consideration. Abdul Aziz versus Masoom Ali. Correct answer is the party has done nothing in response to unilateral promise and hence no consideration. In C. Dutton versus Poole, the correct answer is the agreement may be enforced by the third person for whose benefit agreement was made. And D. Tweddle versus Ettingson, the correct answer is no stranger to the consideration can take advantage of contract although made for his benefit. Which of the following is the subject matter is dealt under the case law Chinaya versus Ramaya? C. Consideration. In the case of McGregor versus McGregor 1888, the wife withdrew her complaints as the husband entered into an agreement with her on the condition that if she withdrew her complaints and refrained from pledging his credit, he will pay for her an allowance. Correct answer is parties had the intention to have a binding contract between them. The case Balfour versus Balfour deals with intention to create legal relationship. Intention not to create a legal relationship was clear from the conduct of parties. Which among the popular cases deals on the topic? Correct answer is Balfour versus Balfour. The case of Mohri Bibi versus Dharmodash Ghosh. Options is the decision of Supreme Court of India regarding extraordinary contracts has laid down that in India minus contract is void ab initio. Mohri Bibi versus Dharmodas Ghosh, void ab initio, has laid down that India's minor contract is void ab initio. Mohri Bibi versus Dharmodas Ghosh is an important case. Again, it has been asked minus contract. The case of Mohri Bibi versus Dharmodas Ghosh is based on the provision of Indian Contract Act Section 11. Which decision has laid down to the principle that contract by minor is void ab initio? Mohri Bibi versus Dharmodas Ghosh. Read assertion and reason, and with the help of quotes given below, point out the correct explanation. Assertion. In Mohri Bibi versus Dharmodas Ghosh, Sir Lord North observed the question whether a contract is void or is voidable does not presuppose the existence of a contract within the meaning of Contract Act and can arise in case of an infant. Reason. Ever since this decision in Mohri Bibi versus Dharmodas Ghosh, it has been doubted that a minor's agreement is void. Both A and R wrong. Consider the following statement and give the correct answer with the help of quote given below. The case of Mohri Bibi versus Dharmodas Ghosh. Options are: has laid down that minor's contract becomes valid when he attains majority. Is the decision of the Supreme Court of India regarding minor's contract. Is the decision of the Privy Council regarding voidness of minor's agreement. Has laid down that the contract without consideration is void. Correct answer is C. Is the decision of Privy Council regarding voidness of minus agreement. In Mohri Bibi versus Dharmodas Ghosh was finally decided by Privy Council. Which of the following was never held or observed by the Privy Council in Mohri Bibi versus Dharmodas Ghosh? Option A. An agreement made by a minor is a void. This was observed. The minor's agreement being void, he could not be asked to repay. This was observed. Section 64 and 65 of the Indian Contract Act 1872 allow compensation to be made by a person who gets undue benefit in a case, but those sections do not cover the case where the agreement void ab initio in the case of minor. This also was observed. So the question here is which was never held. Therefore, D is the right answer. Since the loan had been given to the minor with the full knowledge about his infancy, the money lender can still be asked to be compensated under Specifically Act 1963. This is the right, but this was not observed in Mohri Bibi versus Dharmodas Ghosh. Match list 1 and list 2. Kundy versus Lindstate, B. Tin versus Halfman, C. Roberts versus Gray, and D. Hadley versus Baxendale. Correct answer for A. Kundy versus Lindsay is mistaken identity. Tin versus Hoffman, the correct answer is crossovers. Roberts versus Gray, correct answer is minors agreement. And D. Hadley versus Baxendale, correct answer is measure of damages. Which of the following cases related to the issue of minority in the contract law? Correct answer is all of the above, and these cases are Khan Gul versus Lakha Singh, Ayodhya Prasad versus Chandan Lal, Mohri Bibi versus Dharmodas Ghosh. In Jyotendra Bhattacharjee versus Mrs. Sona Bolon Bora, it was held that the onus of proving unsoundness of mind of a person always rests upon the person who alleges such a state of mind of another person. This was held in Jyotendra Bhattacharjee versus Mrs. Sona Balon Bora. Fraud was defined in a well-known English case, Derry versus Peake. Match list 1 and list 2. List 1 says mistake as to subject matter of contract. A. Mistake as to non-existent subject matter. B. Mistake as to title or right. C. Different subject matter in mind. And D. Mistake as to substance, nature, quality of matter. The correct answer is for A. Mistake as to non-existent subject matter. Gustavus Courtier versus Robert Hastig for A. Mistake as to title of rights. Correct answer is Bell versus Lever Brothers Limited. Different subject matter in mind. Correct answer is Raffles versus Wichelhaus. And D, mistake as to substance, nature or quality of subject. The correct answer is Sheikh Brothers Limited versus Optioner. Again, the question is relating to match the following. Here, list 1 is types of vitiating elements of a contract and list 2 is relevant case law. Types of vitiating elements of a contract: A, undue influence; B, misrepresentation; C, fraud; and D, mistake. So the correct answers are, for undue influence, correct answer is Lancashire Loans versus Black. For misrepresentation, correct answer is Nursery SPG versus Vug and Company Limited, Ray. Fraud, correct answer is Derry versus Peak. And for mistake, correct answer is Jagannath versus Secretary of State for India. Lancashire Loans versus Black. Misrepresentation, Nursery SPG versus Vug Company Limited, Ray. Fraud, correct answer is Derry versus Peak. And for mistake, correct answer is Jagannath versus Secretary of State for. According to Lord Herschel, in the case of Derry versus Peak, fraud is proved when it is known that false representation has been made. Options are A, knowingly; B, without belief in its truth; C, recklessly, whether it is true or false; and D, any of the above. Correct answer is D, any of the above. Knowingly, without belief in its truth, and recklessly, whether it is true or false. Again, the question is match the following: concept and decision. List 1 is concept and list 2 is decision. Here, option in the list of concept, option A is undue influence, B, fraud, C, mistake as to identity of parties. For undue influence, correct answer is Lardli Prasad versus Karnal Distillery Company. For fraud, correct answer is Derry versus Peak. This we have already discussed. And mistake as to identity of parties, correct answer is Ingram versus Little. In Khemchand versus Behram 1888, in context of public policy relating to a contract, it was decided that help given or promised to a dancing girl is not tainted with immorality. Which one of the following cases can enshrine the present position of the doctrine of public policy in India? Correct answer is Gherulal Parekh versus Mahadev Das. Match the following: list 1 and list 2. List 1 consists of heads of public policy: A, trading with enemy; B, trafficking in public offices; D, interference with administration of justice; and D, marriage brokerage contracts. We have to match them with the relevant case law. Correct match with the heads of public policy with case laws are trading with enemy. Correct answer is Nand Kishore versus Kunj Bihari Lal. Trafficking with public offices, correct answer is Girdhari Singh versus Neeladhar Singh. Interference with the administration of justice, correct answer is Aposte versus Bowden. Marriage brokerage contracts, correct answer is Shiv Sharan Lal versus Keshav Prasad. In which of the following cases the Supreme Court struck down a clause in the service agreement whereby service of a permanent employee could be terminated by giving 3 months notice as unreasonable and opposed to public policy? Correct answer is Central Inland Water Transport Corporation Limited versus Burju Nath. In Carlyle versus Carbolic Smokeball Company, the definition of waging agreement was given by B, Justice Hawkins. The nature of waging agreement was explained in Carlyle versus Carbolic Smokeball Company. The facts of Griffith versus Brymere would attract Section 20 and facts of Krell versus Henry attract Section 56 of the Indian Contract Act. Which of the following case is related to the doctrine of frustration? Correct answer is Krell versus Henry. Which of the following case is related to the doctrine of frustration? Correct answer is Satyabharat Ghosh versus Magnera. The first case on the doctrine of frustration as decided by the Supreme Court of India is Satyabharat Ghosh versus Magnera. It is the first case decided on the doctrine of frustration by Supreme Court of India. Satyabharat Ghosh versus Magnera Bangur, 1954 Supreme Court, is a case on doctrine of frustration. Which of these precedent is related to doctrine of frustration? Correct answer is Satyabharat Ghosh versus Magnera Bangur. Which of the following pairs is correctly matched? Mohri Bibi versus Dharmodas Ghosh. This is the correct match. It is related to minus agreement. Hadley versus Baxendale. Free consent. This is also incorrect. Satyabharat Ghosh versus Magnera. Frustration of contract. This is the right pair matched. Lalman Shukla versus Gauridat capacity contract. This is also wrong match. Doctrine of frustration was laid down by the first time in Taylor versus Caldwell. For Supreme Court, the correct answer, if first time by Supreme Court, the correct answer will then be Satyabharat Ghosh versus Magnera. But it is asking was laid by the first time. Then the correct answer will be Taylor versus Caldwell. Read assertion and reason and answer using code given below. It is well settled that if and then there is frustration, the dissolution of the contract does not occur automatically. It depends on the ground of repudiation or breach, or on the choice or election of either party. It does not depend on the effect of what has actually happened on the possibility of performing the contract. Because Lord Wright laid down this principle in Denny versus Mott and Dickinson Limited versus James V. Fraser and Company Limited. Correct answer is both A and R are wrong. Assertion and reason both are wrong. In which case the following doctrine of frustration was recognized in India? Correct answer is Satyabharat Ghosh versus Magnera, Bangur and Company. Question number 1. In the Nash versus Inman case, the issue was, answer is A, minus liability. Doctrine of unjust enrichment was laid down by the Supreme Court in which of the following cases? Correct answer is Maftalal Industries versus Union of India. The case Nash versus Inman 1908 is related to necessaries. Consider the following statements. Statement 1. Moses versus Macfarlane is a prominent example of theory of unjust enrichment as propounded by Lord Mansfield. According to this theory, the demands of justice and equity is to prevent the unjust enrichment of one person at the cost of another. Statement 3. Sinclair versus Borgham has propounded the theory of implied in fact contract to elaborate the nature of quasi-contracts. Choose the correct option below. All the statements 1, 2 and 3 are correct. State of West Bengal versus B.K. Mandal and Sons AIR 1962 SC 779 is an interpretation of which section of Indian Contract Act? Correct answer is section 70 of Indian Contract. Consider the following statement. Moses versus Macfarlane is a prominent example of theory of unjust enrichment as propounded by Lord Mansfield. According to this theory, the demands of justice and equity is to prevent the unjust enrichment of one person at the cost of another. Statement 3. Sinclair versus Borgham has propounded the theory of implied in fact contract to elaborate the nature of quasi-contract. Choose the correct option from the given below options 1, 2 and 3. This means that all the three statements are correct. Moses versus Macfarlane 1555 to 1774 is a case relating to a theory of unjust enrichment. The case of Hodgster versus De La Tour deals with anticipatory breach of contract. The case Frost versus Knight 1872 is related to anticipatory breach of contract. The principle of assessment of damages for breach is given in Hadley versus Baxendale. Hadley versus Baxendale is a leading case on remoteness of damages. The principle contained under section 73 of the Indian Contract Act is based on option A, Hadley versus Baxendale. Section 73 of the Indian Contract Act incorporate rules from which of the following cases? Correct answer is C, Hadley versus Baxendale. Match list 1 and list 2. List 1 says A, remoteness of damages. B, proof to loss to be given to claim special damages. C, loss of profit is special loss. D, consequences of delay in transit. Here the correct match for the particular question is A, remoteness of damage. The correct answer for this is Madras Railway Company versus Govind Rao. Correct match. Proof of loss to be given to claim special damages. Correct answer here is Chief Secretary of State of Gujarat versus Kothari and Associates. This is the correct match of B. Loss of profit is special loss. Here the correct answer is Krishan Das at Thakur versus Saran Engineering Company Limited. And D, consequences of delay in transit. Here the correct answer will the last remaining option, Union of India versus Steel Stockholders, where two parties have made a contract which one of them has broken. The damage which the other party ought to receive in respect of such breach should be such as may fairly and responsible be considered either arising naturally or responsible be supposed to have been in contemplation of both the parties at the time of entering into contract. This statement was laid down in the case of Here the correct answer is Hartley versus Baxendale. Concept that says unfair or unconscionable contracts or clauses should not be enforced is known as C. Culpa and contrahendo. Which of the following is not correctly matched? Here the correct answer is, let us see the first entire option. Coercion, Chikkam versus Ammiraju Chikkam Seshamma. This is the correct match. Liquidated damages, Dunlop Pneumatic Tire Company versus New Garage and Motor Company. This case is related to liquidated damages. Impossibility of performance, LOP Prasad and Sons versus Union of India. These all three are the correct statement. Question asks is which of the following is not correctly matched. So public policy, that is Hadley versus Baxendale, here it is given is not correctly matched, in which case it was held that the state government was in position of a bailee in relation of goods seized by its officers and was therefore bound to take reasonable care of the seized goods. Here the correct answer is State of Bombay versus Maimun Muhammad Haji Hassan. And which of the following judgments? A constitution bench of Supreme Court has held that the sale and installation of a lift is a work of contract. The correct answer is B. Cone Elevators India Limited versus State of Tamil Nadu. Match list 1 and list 2. List 1 suggests option A. Lalman Shukla versus Gauri Datta, B. McPherson versus Apanna, C. Banwari Lal versus Sudarshan Dayal, and D. MC Chaku versus Bank of Travancore. Now let us see the correct match in list 1 and list 2. So the option A, Lalman Shukla versus Gauri Dutt. Here the correct match will be general offer. In B, McPherson versus Apanna. The correct answer here will be invitation to offer. And C, Banwari Lal versus Sukhdarshan Dayal. Here the correct answer will be intention to create legal relationship. And the last and the remaining option, MC Chaco versus Bank of Travancore. So the correct answer will be first, privity of contract. Match list 1 and list 2 containing cases with list 2 containing respective areas of contract and select the correct answers using the code given below. List 1 says A. Balfour versus Balfour, C. Feldhaus versus Bentley, C. Krell versus Henry, and D. Harvey versus Facey. Let us find the correct match. A. Balfour versus Balfour. Here the correct answer will be intention to contract. And B. Feldhaus versus Bentley. Here the correct answer will be communication of acceptance to offerer. Correct option for C. Krell versus Henry is frustration of contract. The last option, Harvey versus Facey. In this the correct answer is invitation to receive offer. Again there is a question of match the following. Match the provision in the list 1 related with the cases in list 2 and select the correct answers using the codes given below. Let us read the statements of list 1. A. Statement of price is not an offer. B. Exception to privity of contract. C. Acceptance must be communicated to the offerer. And D. No estoppel against a minor. So here correct answer will be for A. Statement of price is not an offer. Correct answer is 3. Harvey versus Facey. And exception to the privity of contract, correct answer in this is Khwaja Muhammad Khan versus Hussaini Begum. And C. Acceptance must be communicated to the offerer. Here correct answer is Feldhaus versus Bindley. And no estoppel against a minor. Obviously the correct answer is Mohori Bibi versus Dharmodas Ghosh. Again the question is of match the following. List 1 says Lalman Shukla versus Gauri Datta, B. Tweddle versus Ettingson, C. Balfour versus Balfour, and D. Khan Gul versus Lakha Singh. Now let us match list 1 with the list 2. List 1, Lalman Shukla versus Gauri Datta. Here the correct answer is general offer. Tweddle versus Ettingson, B. The correct answer is privity of contract. And C. Balfour versus Balfour. Here the correct answer is intention to contract. And the last option, Khan Gul versus Lakha Singh. The remaining option, restitution, is the correct answer. Now let us again discuss the match the following. Question number 9. List 1 says invitation to offer, B. Anticipatory breach, C. Restitution, and D. Implied contract. The correct answer here will be for among list 1 and list 2. Option A, invitation to offer. The correct answer is Harvey versus Facey. Anticipatory breach, option B. The correct answer of anticipatory breach will be Rochester de la Tour. And for C, restitution, the correct answer for restitution is Leslie R Limited versus Shell. And for D, implied contract, the last and remaining option, Upton Rural District Council versus Powell. The correct match will be for implied contract. Now let us discuss the last question of this series. Match the following. Match list 1 and list 2 and select the answer by using the code given below the list. List 1 says A. Satyabharat Ghosh versus Magnera, B. Rajrani versus Prem Adib, and C. Entros Limited versus Miles for East Corporation, and D. Harvey versus Facey. As we all have discussed Harvey versus Facey lot many times, the answer for Harvey versus Facey is invitation to offer, option 1. And for A. Satyabharat Ghosh versus Magniram, the correct answer is Doctrine of Frustration. And then second, Raj Rani versus Prem Adib, correct answer for B is 3, minus agreement. Raj Rani versus Prem Adib, minus agreement. And C, Entorts Limited versus Miles for East Corporation. For C, the correct answer is communication of acceptance. And D, Harvey versus Facey, we have already discussed, is invitation to offer. And the remaining one, Doctrine of Frustration, here Doctrine of Frustration was discussed in Satyabharat Ghosh versus Magnera. So this is the last and concluding video of contract law related case laws. Again, we will meet with another case laws related MCQs. Please follow this series regularly and consistently. Thank you so much. Please like and subscribe us.